Let's do it. Well, hello, everybody, and welcome. My name is Kevin Kell. I am Oxford College 75, Emory College 77. And I want to thank you all for registering for this event. We have had an overwhelming response to our promotion of this event. It's a far cry from the 5 registrants we had in the June of 2020 when we did our first digital event. So we appreciate your support of the network. Since 2020, we have produced, I say we, I mean the board of directors and I have produced 50 presentations, either digital or in person. And one thing that we've noticed is that alumni our age want to see programming related to healthcare topics of interest to us, and also programs on estate planning. Those have been our most well-attended events. Um, because this has been so popular and so much interest in the subject, I wanted to share just a quick personal story. And before I do, I want to reemphasize that Emory Global 60 Plus Network is all about Emory giving back to the classes of the 50s, 60s, 70s, and early 80s. It's one of Emory's, if not Emory's, most valuable cohort of alumni. A few months ago, my wife and I had the opportunity to revisit our wills. And I had the idea of establishing a scholarship fund at Oxford College. When I landed at Oxford in the fall of 1973, I was a first generation student. My parents did not have the opportunity to go to college, but they sure as heck made sure that I would. And it wasn't going to be just any place, it had to be Emory. Um, the scholarship will benefit first generation students, help them pay for books and uh, uh, tuition and personal items while they're there. So all that to say, if philanthropy is important to you financially or emotionally, just think about Emory when you're making those decisions. There's so many wonderful um, opportunities to support everything from Alzheimer's research to student flourishing and scholarship. So think about that. Now I want to introduce Linda Smith, who is president of the 60 Plus board and the hardest working person I know. She is going to introduce our speaker, Missi McMorries. So, Linda, let's get started.
Thank you, Kevin, and welcome everyone. I am also a 1986 MBA graduate from the business school and happy to be working with the 60 Plus steering committee for this wonderful cohort. So thank you all for participating today. We are so excited to have my friend and the wonderful Missi McMorries as today's presenter on behalf of our group. She's an attorney with over 40 years of experience and is currently a partner with Taylor English Duma, where she focuses on trusts, estates, business succession planning, and corporate transactions. In keeping with our tradition to utilize members of the Emory family for presentations like this, Missi also spent over 12 years enlightening the wonderful students of the law school as an adjunct professor in the Transactional Law certificate program. So glad to have a member of our pseudo family involved with this today. I now turn the floor over to Missi to share insights of her estate experience and that have given her the ability to help us know how to prepare surviving family members for the inevitable. Take it away, Missi.
Linda and Kevin, thank you so much. I'm pleased to be with all of you. Before I start, I must give you my obligatory disclaimer, which is printed at the bottom of the first page of the presentation. But this presentation is for informational purposes only. It does not constitute, and I will not be giving legal advice. No attorney-client relationship has been formed or will be formed by any communications that I may make today, and the opinions and the materials expressed are solely those of the author, that's me. And I made all the decisions as to its content, with some coaching from Linda, I must add. So, okay, why don't we dive in? I understand that you all have already had your wills talks and those types of things. I'm not going to talk about wills, but I am going to talk a little bit about what happens with the will after you die, or your estate if you don't have a will. And if you don't have a will, shame on you, but I'm not going to chastise you much more than that. You know what you need. Everybody hears about the word probate. Probate is a process through which your assets are distributed following your death, and is a legal proceeding filed with the court system. I will be speaking in the context of Georgia law, by the way. So if you are listening from some other state, some of the things I might say about probate that are applicable in Georgia may not be applicable in your state. There are basically in probate two types of estates. Those that are testate, fancy word for meaning you have a will, and those that are intestate, which means that you don't have a will. Sometimes you've got mixed estates where a will may dispose of some of your property, but totally ignores other chunks of your property. So you may have both testate and intestate assets that are distributable. And if that's the case, a certain set of statutes apply to the intestate portion, and another set of statutes and administrative procedures apply to the testate portion. That doesn't happen very often. However, there is this concept called probate and non-probate assets. And you'll see at the bottom, why is this important? It's because how your assets are titled may largely determine how your estate is distributed. So probate assets, generally speaking, are those that are subject to the will and are usually assets that are titled in the decedent's name. So you have a car title, it's in your name, you die, that car is a probate asset. Non-probate assets are those assets that are not subject to the will, but are transferred by contract or operation of law outside of the will. Good example, life insurance. You purchase a life insurance policy, you have your daughter as the beneficiary of that policy. What you have there is a contract between you and the insurance company that at your death, they're going to pay your daughter. Doesn't go through probate, is not handled through the whole probate legal procedure. The same can apply to some of your retirement accounts, unless you have designated, and in all of these cases, unless you have designated your estate as the beneficiary. So if you get a life insurance policy, you name your estate as the beneficiary, it's going to flow into your probate estate. Same thing with your retirement accounts. Joint accounts are one that most of us are familiar with. You have a joint checking account with your spouse, and one of you dies, that account automatically flows to the survivor of the joint holder. That can also apply to your home. If your home is set up as what we call joint tenants, or joint tenants with the right of survivorship, whoever dies first, the home then goes to the survivor. So as you can see, how the title flows goes who winds up getting that property. So sometimes it's very important to check that. This is particularly important for you to do because the next step that I'm going to be giving you is let's go and look at your will. So next slide, please. Thank you. I want you to pull out your will at some point after this talk and look at it with new eyes. Read it as if you've never read it before. And make sure that, one, you understand what it says, and two, you still intend for your property to go as written in the will. Sometimes this can be pretty obvious that you may have written a provision in your will that disposes of the vacation home up at Lake Burton, and it turns out you sold that 20 years ago. Okay, so that may not need to be addressed at all anymore. It may be that you have a whole new chunk of assets that you need to distribute and add to your bequests. You also need to consider whether the structure of the will makes sense. And I don't intend to get off in the weeds on estate taxes, but for a lot of people who made wills 15 or 20 years ago, the structure of the will was set up with what we call AB trusts, where a trust was set up to hold your estate tax exemption, and the balance went into a trust for the surviving spouse. Because the estate tax exemption amount over the past 15, 20 years has increased from $650,000 to now $13.6 million per person, that can make a big difference as to how those trusts in the will are funded. And then you also have to figure out whether having a trust in there to begin with still makes sense. The other thing you're going to want to look at are your beneficiaries. You know, standard family members, and that may be how your will is written. However, you may have decided to make specific bequests of cash or certain items, valuable items, to specific people. You may no longer like that person. That person may have died. The amount that you've set aside for them may be either too much in accordance with your asset structure now, or not enough. So it's important to go through that. Oftentimes I see charitable gifts in wills that are administered that for charities that the testator had no interest in anymore. It was more involved in some other kind of charitable activity. So charitable gifts should be looked at with the same type of scrutiny as you would give any beneficiary. The other thing you need to look at are your fiduciaries. That's who is your executor and who is the trustee of any trust that you've set up. Sometimes those executors aren't alive anymore, or the trustee isn't alive anymore, or the trustee you thought was a really trustworthy person and it turns out they've absconded with the family jewels. You may want to change those fiduciaries. So everything should kind of be looked at as with brand new eyes. Most important, I think, is, do you understand what the expectation of your heirs is? I see in my practice, a lot of times there are disgruntled heirs. And what that usually entails is that a parent is making bequests to their children in unequal amounts because they believe one child is either more deserving or more needy or whatever. And that may make perfect sense when it was written. It may make perfect sense now, but if you haven't told your children that that's what you're doing, it can lead to hurt feelings and the sort of the Smothers Brothers, mama always loved you best type of concerns that can make sometimes the probate process testy among siblings. So I would advise you to have a sit down with your heirs, particularly your children, as to what your plan is with respect to your distribution of your assets. Okay, next slide, please. Let's also then, since you've taken a look at your will, let's look at your financial condition with new eyes. And when I say, what are your asset classes, we tend to think of those from in a financial manner. What is your cash on hand? What are your marketable securities? What real property do you own? Do you have collectibles? Do you have life insurance? Do you have retirement plans? All of those should be looked at, listed, and you should, based on our talk earlier about probate versus non-probate assets, look at how they're titled so that you can understand how those assets are going to flow upon your death. You also need to look at your liabilities. One of the things in probate is that before the heirs can get anything, the debts of the estate must be paid. If the debts of the estate aren't paid and the estate is distributed to the beneficiaries, the executor can be personally liable for those debts. So your executor is going to be very interested in understanding your debt structure and knowing how knowing what your liabilities are at the time of your death. Keep in mind too that oftentimes liabilities in your estate aren't necessarily your monthly bills, credit cards, all of that stuff you need to understand, but you could have some contractual obligations that the estate will be looked at to fulfill, such as guarantee of a loan. So keep those types of things in mind and make sure you've got a handle on what those sort of what we call contingent liabilities are. The last thing you want to look at, maybe the first, is what are your sources of income? Are you still working? Do you have pension, IRA, and 401k income? What's going to happen, particularly with your pension, IRA, and 401k income following your death? Presumably, if you're actively employed, that will cease, though there may be some death benefits, et cetera, that would be payable on your death. And or company provided life insurance. That's one that people forget. So understand what those benefits are that would be triggered by your death. And then, of course, you need to understand any government income that you're getting from government entities, which Social Security being the most obvious. If you are a military veteran and receiving VA or Defense Department benefits, those also need to be considered. And more particularly, you need to know who to get in touch with so that at the point of your demise, you can inform the government entities of your passing, or your executor can inform them of your passing. Next slide, please. Okay, so you've done sort of a little mini inventory of your will and your assets. Now, I really want to sort of have a philosophical discussion in a little bit about what is your stage in life. And I have a friend, it's probably not original with her, but she talks about in retirement, the go-go years, the slow-go years, and the no-go years. And they are kind of how they sound. You may be hiking in Bryce Canyon and doing really strong travel, having a very active life. Those are what we call your go-go years. Your slow-go years or when things are slowing down. Maybe physically you have some limitations, you aren't as active, and age is beginning to creep up on you. And of course, your no-go years are probably at the point where you are either getting some help and care with your daily needs, or you just simply are much less active. I might have to tell you from an example standpoint, I'm going to use my dear mother, who died at the age of 100 back in April. And I can tell you that for her, her go-go years lasted through her 80s. She was active and traveled and did all those types of things and was a whiz on the stock market and took care of all of her financial stuff. Slow go for her began in her late 80s and into her early 90s, when all of a sudden I started picking up, paying some bills. Particularly, it started out with paying her taxes. She was taking fewer vacations, fewer trips, and basically slowing down. She also, bless her heart, started losing mental faculties at this point. It was gradual. But I will tell you that during her slow-go years, she was still driving up until the age of 93. When we took the car away, it was an involuntary thing on her part. She didn't speak to me for 6 weeks, but she did get over it. But it was for her concern and her safety. And then in her no-go years, she was physically fine, but had an advanced stage of not Alzheimer's, thank goodness, but senile dementia. And she was, and during her part of her go-go years, but into her slow-go and no-go years, she was in a continuing care facility. The reason I bring this up is that I remember her mother had Alzheimer's disease, and she said, and having dealt with and taken care of her mother during this part of her mother's life, she always said to me, "I will never fight you with respect to going into a care community. I understand the need for it." And she was pretty good about that. But as time went on, she became more and more, particularly when her mental faculties started failing, she became a little more controlling, fearful, and reluctant to let go of a number of things. I raise that because this is something that all of us are going to have to face. I am now. I look at my fading memory on a number of things. And it is important that you face your aging process, however it's progressing, in as rational a way as you can, because there are things that you can put in place that will make your life, particularly during the slow-go and no-go years, much easier for both you and your caregivers and family members. And we're going to talk about some of those. So think about where you are in your life and what might make sense for you. Let's go to the next slide. Do you have a financial power of attorney in place? Who is the agent and the backup agent for that power of attorney? Now, most lawyers who prepare your will usually prepare the financial power of attorney at the same time. Again, before you really need it, it's important for you to take a look at that financial power of attorney and make sure the persons that you've designated as the agent to act for you in financial matters is somebody you still want to make those types of decisions. The other item that I urge you to relook at is your advanced medical directive for healthcare. It's also called the living will. In Georgia, it covers a number of things, but the most important thing for most of my clients is, are your end stage desires clear? It's who are the agents that make those decisions on your behalf? And as I point out to my clients, those are decisions that that as long as you can communicate with your doctor is going to listen to you. This is when you are no longer able to communicate to your medical provider what your desires are in that respect. So when you're looking at your will, look at your financial power of attorney and your advanced medical directive. Make sure that these people are not your contemporaries, because they may have the same types of mental or physical failings that are keeping you from being able to act on your own behalf. So it's helpful if you can select somebody, particularly in your no-go years, that is at least a generation below you. Then there are also conservators and guardians. These are court-appointed individuals who can make these types of decisions for you. They are court-appointed and report to the court. They can be family members. They can also be total strangers that are appointed by the court. They are generally not necessary if you have a good financial power of attorney and advanced medical directive in place. And so I urge you, excuse me, to rely on those two documents as opposed to the courts to take care of your interests. Okay, next slide. It's getting grim, isn't it? Okay, so you've thought through all of this, all of these issues. And so what do you want to tell your family? Well, the first thing is to get together, just maybe in a separate place, maybe you keep it with your will, a list of your trusted advisors. And that can be your accountant, your attorney, financial advisors, your insurance agents, your doctor, but really important, who is the first call person? Who is the person that's going to take charge of contacting all of these people in the event of your death? And that may or may not be your executor. That could be a close friend or family member or someone that knows all of this information. Okay. But first and foremost, don't just write down their name. Give full contact information, addresses, phone numbers, email, please. It makes life so much easier. Okay, next slide. Online access. This is a real evolving area. I don't know about you, but I probably have 200 plus websites or places where I have an online account, where I have a password floating around. And it seems like every single one of them have different protocols for setting a password. I can't remember any of them. And so I try and save them to something that is secure. I used to write them all down in a notebook back in the old days. Don't do that anymore. I do save them in some kind of vault. Of course, it's important that if you change your password on a particular site, that you update the password vault if it doesn't do that automatically for you. Some phones, I have an iPhone, they have its own password vault, which stores all these passwords for you and can dream up really, elaborate passwords. the point is that whoever is going to be helping you either during your no-go years or after your passing is going to need access to your online accounts. So you need to anticipate that, make sure you know who that person is, and give them the information so that they can access those accounts. Think about your cloud storage. Who is going to inherit those 5,000 photographs that are up in the cloud? If they're not in the cloud, think about who's going to inherit all of those family documents that are sitting in a box in your storage area. Same thing. You might want to think about passing those documents on if you don't have the energy, which I don't, which is to scan them all and put them all up in the cloud. You can at least think about passing that type of information on, particularly when you hit your slow go and no go years, so that somebody has them and can recreate some family history as needed. Next slide. Okay, we've already kind of talked about, sorry to be duplicative, who the contact information for your accountant, financial advisor, and attorney, but also you need to make a list, if you can, for your first call person. Who should they get in touch with and in what order once you pass? This can include email and phone numbers for your extended families, some membership organizations I'm sure Kevin would like to know, and also government entities. We talked about that earlier, but how to get in touch with Social Security for sure, and any other government entities. Also, your employer, if your employer is paying pension and retirement benefits, how those could go. And of course, you're going to want to notify your financial advisor, accountants, and attorneys. So that should be the job, hopefully, of your first call person. And who will hopefully eventually shift that over to your executor if they wind up not being the same person. Okay, next slide, Ginger, thank you. Okay, your funeral. Please, please, please don't leave your family flat-footed with this. I knew my mother wasn't going to live forever. And I knew that she had probably would have some certain definite plans regarding what she wanted for her funeral, but we never really talked about it other than in passing. So 2 days after she was dead, I was working with the priest at my church and filling out a questionnaire as to things like, what hymns do you want? What readings do you want? What do you even want a funeral? Are you going to be cremated? Are you going to be buried? Where is all of this going to take place? So if you haven't made arrangements or haven't expressed your thoughts and don't have that, please do. That should be something that you at least can sketch out the bare bones of, to give your family member some guidance as to what to do. And many houses of worship have funeral planning guides. A number of the funeral homes have funeral guides, and also have pre-planning where you can prepay for your cremation or your casket and your arrangements before you go. So with that, I'll open it up for questions. Is everybody depressed?
Thank you, Missy. Yes, I personally am depressed. I'm going to call my parents when we're done. We do have a few questions. One of the questions, are the password vaults really secure? Worry about hacking, or is that a problem?
You know, you always worry about hacking. A parallel to that is I had some clients who were into cryptocurrency and blockchain. And that's such a complicated thing where if you don't have whatever the key is to blockchain, you've lost all this money. Okay. And I looked at them and they were all pretty tech savvy people. And I said, how much longer do you think it's going to be before blockchain is hacked? And they couldn't give me an answer, but they recognized that blockchain, which is probably the most sophisticated encryption situation, someday someone is going to hack it. Someday someone's going to hack everything. Okay. It is, as I say, there's nothing that is guaranteed in this world. All you can do is the best you can do. Like I said, I feel fairly comfortable with the password function on my iPhone. So far, so good. But your biggest protection on getting hacked is to monitor your financial position. And that means I go to the website, my online accounts at least 2 or 3 times a week to make sure that the balances are what I'm expecting them to be. I also have subscribed, probably because other people who have my passwords have been hacked. And so they immediately sign you up for monitoring, credit report monitoring. Okay. I have several of those going right now. So that's always helpful. But most important thing you can do, I think, to protect yourself is to put a lock on your credit reports. You can unlock them if you need to apply for credit. I don't generally need to apply for credit as much as I used to, so I don't worry about it. But a lock or a block on your credit reports can really save you a lot of heartache.
Another question is, when does it make sense to transfer assets to heirs to avoid estate tax?
Well, generally speaking, you should wait to pass your assets to your heirs after you die. And the reason is at least under the current tax law, is one of stepped up basis. So if you want to pass, say, General Motors stock that you bought 30 years ago for $10 a share, and it's now worth $100 a share, if you gift that stock to your grandson, he's going to be thrilled, but he's going to get what we call a carryover basis in that asset, which means if he turns around and sells that $100 stock, he's going to pay capital gains tax on $90 of that gain. If you wait and pass that at your death, you get something, or your heirs will get something called stepped up basis, which means that your entire portfolio, or whatever your asset is revalued to its value as of the date of death. So if that General Motors stock was selling for $90 a share on the date of death, and your grandson turns around and sells it a month later for $100, he's going to pay capital gains on $10 as opposed to $90. So those are the things you need to keep in mind before you start doing a bunch of what we call inter vivos asset transfers. For those of you who have estates that would be subject to federal estate tax, which today is 13.6 million per person, or around 27 million for married couples, you might want to get with a very good estate tax planning person to help you preserve that exemption amount and set up a series of trusts or whatever so that you can protect that exemption. The reason for that is that that high exemption amount is sunsetting on January 1, 2026, and is being cut in half. So what was once a $13.6 million exemption amount will come down to $6,700,000. I'm sorry, math is not my strong suit, but will come down considerably. So, and for those of you who are fortunate and in those situations, and if the estate tax exemption now is cut in half, anything that you have in excess of that estate tax exemption is taxed at 40%. So that's a significant number. That's a big tax number and something you should take into account. Fortunately, most people, the vast majority of people, don't need to worry about that. Some who are in the $5 to $7 million range with spouses, they might want to take a look at their federal estate tax structure. But as I say, that's a topic for another day.
What do you suggest doing if the will is lost and belongs to an elderly parent that has dementia and cannot make a new will? Can you contact an attorney to draw up an original and get it certified by the beneficiaries, or how does that work?
If you have a copy of the original will, there is a court procedure that you can go through where the court may, and I emphasize may, accept the copy. The problem that you have is that the law presumes that if the will cannot be found, the testator destroyed it. So, so the proof there is, and that's why it's a court case to prove, gee, did the testator really destroy it? It's a long, complicated process, but I wish you luck. It is a difficult procedure to go through, and if the court will not accept a copy of the will, then your mother or grandmother or whoever may be considered to have died intestate.
Can you address any special provisions for solo agers? How to make it easy for those who volunteer as health surrogates, successor trustees, and protecting against abuse, oversight, etc.?
Well, that is to have someone, hopefully a family member, who can monitor those, particularly, I think you're talking caregivers, okay? Who, sometimes maybe it makes sense to have somebody on tap who can monitor your financial situation, maybe your financial advisor, or someone like that, to make sure that your assets aren't being drained. But it's a difficult question. It's a tricky question. There are laws on the books in Georgia on elder abuse where these people, of course, can be prosecuted. Unfortunately, by the time it comes to that, the damage has been done. So my caution to you is to select very carefully who is going to be the person given your power of attorney. Some elders, my mother certainly did this, put me as we had a joint checking account. And so I was able to easily write checks and take care of business for her. It was not all of her accounts because she wanted to make sure that other family members also received distributions from her will. Remember that I told you that if it's a joint account, it automatically goes to the survivor of that account. You can wind up disinheriting your family if you put some other person as a joint holder on your home, your retirement, they're the beneficiary of your retirement accounts, your checking accounts, your brokerage accounts. So be very, very careful in setting up joint accounts, and maybe only do it for those accounts that are there for your day-to-day needs. I hope that helps.
We have another question in the chat that says that they got a trust in the year 2000 and the limit was about $1 million. Now the trust is worth less than 2 million. Is it worth keeping it or dissolving it?
I have no idea.
Okay.
I have no idea. That I am not a financial advisor, and I could not make that evaluation.
Got it. If generation skipping to very young grandchildren, is a trust always necessary?
It's to very young children, yes, it is. They cannot take, they do not have legal competency to take charge of those assets. It's a fairly simple, it can be a fairly simple trust that's drawn up in the will, where you are going to skip their parents and give your estate to the grandchildren. I caution you, of course, that if you do that and you exceed your estate tax exemption, not only is your estate going to be taxed at 40%, but the generation skipping portion will be taxed at 40% as well, or 80%. So approach generation skipping with great caution.
What about doing a joint bank account to avoid probate?
Done a lot. And as I say, we did it with my mom. As far as avoiding probate, a lot of people have heard and are from different jurisdictions where probate is a very difficult process and can be expensive and is not private. In other jurisdictions, Georgia, we're kind of blessed with pretty good probate laws. So avoiding probate shouldn't be the primary motivating factor. What you can do, however, with things like joint accounts is that the beneficiary or the other joint holder has immediate access to those funds.
Do they avoid estate tax?
I beg your pardon?
Do they avoid estate tax?
No.
Okay.
No, that half would have to be tossed into the calculation of what the estate is.
Okay, does anybody have any other questions? You can come off mute and ask. We've gone through most of the online questions. Shelley, sorry.
All right, so I think that maybe a lawyer told me this, is that, for things like, some jewelry, some furniture, that outside the will, it might be acceptable, I don't know what the law is now, to have just a listing of those things with pictures and to whom we want them
Absolutely.
to go, and date and sign it every 6 months. Is that appropriate?
It is, and I do it all the time, primarily because you don't necessarily want to have a specific bequest of Aunt Jane's tea set to Cousin Mary. And then next month you get mad at Cousin Mary and you want to remove her from the will. That gets expensive and awkward, okay? So usually a will contain a provision, or at least wills that most lawyers draft, that say, you will find among my personal papers a list of certain personal property that I want to go to various people. And I can tell you that it is not enforceable. It is what we call precatory, but generally speaking, the heirs honor it and the executor honors it. Okay. So yeah, I strongly recommend for certain specific items. Now, having said that, if there is a valuable item of personal property, like a Van Gogh painting, well, maybe not a Van Gogh, but some family portrait that you know is going to cause controversy in the family, put it in the will. And you want it to go to, like, your nephew thinks he's going to get it, but you really want it to go to your daughter, put it in the will. Make a specific bequest of that item. What you want to do is avoid the fights that can break out to the extent you can. And they usually do arise more with personal property items than anything else, unless you are treating children differently. That also can cause some difficulty.
Dawn, do you have a question?
I do. I'm wondering about, I understand the federal estate tax and the 40% after what, 13 something million and now 6 point something million. That's fine. What about the state?
There's no estate tax in the state of Georgia.
Oh,
That is not true in other states, but it is true in Georgia. Now, don't get the terms confused. There is estate income tax, which is the earnings of the estate before it's been distributed. So there's interest and income and all of that stuff that the estate is earning, and that is taxable to the estate. But as far as a big tax on the assets, the estate tax, there is nothing in, no estate tax in Georgia.
I'm not sure who iPhone 10 is, but you have a question as well?
That might be me. This is Andy
Yes.
Vernon.
Hi, Andy.
Hi. I think you answered one of my questions about the 40%. That's the rate of estate tax once you exceed the 13.6 million limit for 2024, I think.
Correct.
I'm aware that some wills include a clause to prevent contests to the will.
Yeah.
And so they include a statement that any contests to the will in particular domains will result in the disinheritance of the contesting party. I don't know how that works in Georgia.
They are called interim clauses, and they are recognized in Georgia. They need to be pretty carefully crafted, but they are recognized and are put in place and are advisable if you think a fight's going to break out.
Yeah. Thank you.
Ken?
Yes, I was wondering is there a difference between transfer on death and primary beneficiary?
There is a transfer on death. You see those in a lot of times in bank accounts. And just this past General Assembly session, the Georgia finally recognized transfer on death deeds. So you can keep that property, if you execute a transfer on death deed, that means you hold it, you don't need a joint holder, whatever, and it transfers automatically on your death. So yes, there are transfer on death mechanisms, both for financial matters and financial instruments, and now most recently for real property. Until this year, Georgia didn't recognize transfer on death deeds, but they do now.
So that would not go through probate at all.
Correct.
You drop dead and it goes to whoever you want it to go to.
Correct.
That's
Correct.
just what I wanted to hear. Thank you very much.
Hey, Missy, we're gonna take a couple more questions, and then, we're right at 6, so we'll give you a couple more questions. Got a couple people with their hands raised. If you can unmute and ask your question.
I have a question,
Okay,
concerning the step up in basis.
Mm-hmm.
So if husband and wife have a joint account
Mm-hmm.
and there are large capital gains in the joint account,
Mm-hmm.
would it make sense to separate the account into a his and hers and have, say, interest bearing investments in her, assuming the male will pass first, interest bearing instruments with not much or no capital gain in her account? They file a joint tax return, and then the high capital or the low basis stocks in his account, assuming he would pass first, and then it goes through the will, I guess, right? Or is there a step up in basis is my question.
Yeah, the step up in basis is a tax provision. So whether it is a probate asset or non-probate asset, it's going to apply. Okay. If you have, let's say you've got an account with Merrill Lynch, I'll pick on them, and it's in both your names, and one of you dies, your spouse would get stepped up basis on half of the portfolio.
Do you get to choose which half?
Well, probably not. No.
Of course, it wouldn't matter to you anyway, would it?
Right, wouldn't matter to you, but he or she would get stepped up basis on half the portfolio. So if the joint account held 100 shares, it automatically passes to the spouse. The basis of the 100 shares was $100, and the fair market value was $400. Stepped up basis would apply to 50 of those shares.
Okay, thank you.
Mm-hmm.
okay, we have time for one last question, and then Kevin, will wrap it up for us.
I was going to ask about, and maybe you touched on it already and I missed it, revocable versus irrevocable trusts.
Mm-hmm. The irrevocable trust is used oftentimes, as a lot of people
hold on. Shoot.
I'm sorry, I didn't
Sorry,
know.
Missy, something happened. I apologize.
That's okay. That's okay. A revocable trust is, I'll back up, is sometimes called a will substitute. It is revocable at any time by the grantor and is used often, as you said, to avoid probate. Okay. It's also used often for blended families and also as a vehicle for out-of-state real property. So there are a number of uses for it. An irrevocable trust is how it sounds. It's irrevocable. Once you transfer property in there, it isn't coming out unless you go through a rather elaborate decanting provision. But, and also there are gift tax implications if you give property to an irrevocable trust. And I just might add that any trust that is written into a will is revocable at any time by changing the will, but becomes irrevocable once you die.
Great. Well, thank you, Missy. that was just great. My only comment is I think it's time for a cocktail now.
I was gonna say,
And a big thank you to all of you. If this was your first 60 Plus Network event, as I said, we do this monthly. So watch your email for information about digital events, in-person events, and all things related to 60 Plus. For you Atlanta folks, join us on Sunday, the 29th of this month for an in-person event at the Carlos Museum, which all of you know is a treasure. We will have light refreshments, and docents will be available to answer your questions on the current installation, which is really a very interesting show. I look forward to seeing you all again. It'll be in digital will be November. Please remember that my door is always open and that I would love nothing more than to hear your Emory story. So again, a big thanks to all of you, and have a good evening.